Hi, everyone. Good morning, good afternoon, and good evening, whatever you're joining us from. Happy first day of the month, and welcome to the first session of the August series of Lloyd's Academy Asia Pacific, Middle East, and Africa Educational Program for 2024. This is Shai from Market Development Team for Lloyd's Asia, our platform in Singapore. Today's session is about landmark cases on medical negligence and non-delegable duty. Some reminders before we begin. Please feel free to ask questions throughout the session through the comment box at the right corner of your screen, and we'll address them at the end of the presentation. The session will be recorded and uploaded online and can be shared upon request. Some important notes: you can receive your certificate of attendance and claim for CPD hours and uh, fill in the feedback form at the end of the session. The views and opinions expressed in these webinars are those of the speakers and do not necessarily reflect the official policy or position of Lloyd's. The information provided is for general information purposes only, and should not be construed as professional advice. To begin, I'm handing over the time to Wei Ing Tay, Claims Manager for New Line, to introduce our speakers and be the moderator of today's session. Thank you.
Hi everyone, and thank you, Shaira. Good day to all who are here today and taking your precious time to tune into this webinar. We are into the first webinar for August 2024, and for those who have attended other webinar sessions last month, I do hope you stay on, enjoy your time here, get to understand more about the topics the speaker will be sharing shortly. So before we dive right in and passing over to the speaker, allow me to just share a little bit more about New Line Group. We are a specialty insurance group that operates through three underwriting platforms: New Line Syndicate 1218, New Line Insurance Company Limited, and New Line Europe, headquartered in London with offices in the UK, Europe, Asia, Australia, Canada, and Latin America. Our suite of product offerings includes affinity and special risk, cargo. For casualty, you'll be in the areas such as commercial crime, directors and officers liability, product liability, life sciences and clinical trial, medical malpractice and professional liability, and last but not least, space and species. New Line's gross premium return is at 448 million in the year ended 31st December 2023, and our 2023 combined ratio is at 91.3%. That said, if you have any further questions or queries about our product offering, please feel free to reach out to my colleagues as shown here. So now, for now, in this webinar itself, we have invited JJ Chan, Managing Partner of CBE, and Phoebe Ng, Partner of CBE, who will share more on the topics landmark cases of medical negligence and non-delegable duty. I had a number of conversations with CBE prior to this and understand that they handle mainly niche litigation work. So if you are able to see on the screen itself, JJ has an extensive practice in civil litigation with particular experience in medical legal matters, insurance and reinsurance law, directors and officers liability, corporate, commercial, and construction litigation. He has been involved in several landmark cases and more than 30 reported court decisions ranging from medical legal to corporate and commercial matters. JJ has also written several articles on medical negligence, institutional liability, insurance and reinsurance coverage, corporate directors and officers liability, tax, commercial, and contractual matters. He has also prepared two booklets, and the first booklet entitled Landmark Cases on Medical Negligence, and the second booklet entitled Effectiveness of Agreed Liquidated Damages Clauses. Furthermore, he's looking to co-author with a world-renowned directors and officer expert. JJ has written articles on the landmark medical negligence cases he and or his firm are involved in. CBE has prepared a compilation of the said articles, which may serve as a useful reference point in this webinar. The link to the materials in the registration contains only one of the articles. So we have now uploaded the full compilation and have pinned it to this chat. We will have to trouble you to download and refer to the same so that today would be a meaningful session and discussion. And now on to Phoebe. Phoebe works closely with JJ in handling matters, in particular the areas of medical legal, insurance and reinsurance law, corporate directors and officers liability. I'll be passing on over to her to give an overview on the landmark medical negligence in Malaysia. Phoebe.
Thank you, Wayne, for the introduction. Hi, everyone. Today I'll be giving an overview on the landmark medical negligence cases in Malaysia, as set out in the materials, which consist of articles written by our managing partner, Mr. JJ Chan, on the said landmark cases. We understand that the Lloyd's team has uploaded and pinned a compilation of the said articles in the chat, and hope you've had the time to download and refer to the said. The landmark cases we will be covering today are Dr. Zul Hasnima, Hassan Basri and another against Dr. Kupu Velumani P and others, citation 2017-8 CLJ 605. We will refer to that case as Dr. Kupu's case. The second case is Dr. Kok Chung Sing and another against Su Cheng Lin and another appeal, citation 2017 10 CLJ 529, referred to as Sunwave case. Dr. Hari Krishnan and another against Megat Nor Ishak Megat Ibrahim and another appeal, citation 2018 3 CLJ 427, referred to as the Eye Hospitals case. Ki Bun Swan and two others against Adventist Hospital and Clinical Services M and three others, citation 2018 6 CLJ 334, referred to as Adventist Hospital case. And Xiao Qing Yi suing through his wife and litigation representative Chow Wai Kien against Columbia Asia Sdn Berhad, citation 20244 CLJ 173, referred to as Columbia Asia's case. We have also prepared a booklet entitled Landmark Cases on Medical Negligence, which contains our said articles together with the written reasons for decision by the appellate and apex court of Malaysia. If you'd like to have a copy, do reach out to us and we will be happy to share it with you. So I shall start off with Dr. Kupu's case, in which our managing partner, Mr. JJ Chan, and our senior partner, Puan Fatiza, were involved. In general, there are two aspects when it comes to standard of care expected of a medical practitioner. First is the standard of care in respect of diagnosis and treatment, and standard of care in duty to advise of risk. The federal court in Dr. Kupu's case made a clear distinction between the standard of care on diagnosis and treatment and the standard of care on duty to advise of risk. So in brief, the applicable standard of care in respect of a doctor's duty of care on diagnosis and treatment is the Bolam test, subject to the qualifications as decided by the English House of Lords, now known as the Supreme Court, in Belito's case. And the federal court had held as well that the test laid down in the Australian case of Rogers against Whittaker, more commonly known as the Rogers test, which was followed and applied by the Malaysian Federal Court in Fu Fiona against Dr. Su Fok Man, citation 2007 1MLJ 593, is restricted only to the duty to advise of risk and does not extend to diagnosis and treatment. So in a nutshell, the Bolam test is the applicable standard of care on diagnosis and treatment, and the question of whether a doctor had breached the standard of care in respect of a doctor's duty of care on diagnosis and treatment is to be determined by the medical fraternity. And the question of whether a doctor had breached the standard of care on duty to advise of risk is to be determined by the court. Next, we will go on to Sunway's case. So in Sunway's case, the federal court held that the doctrine of non-delegable duty as expounded in the English Supreme Court case of Woodland against Swimming Teachers Association and others, citation 2014 AC 537, hereinafter referred to as Woodland's case, applies in Malaysia, and that such a duty would be imposed only where it is fair, just, and reasonable to do so, having regard to the particular circumstances of the case and developed incrementally from existing categories and consistently with underlying principles. Now, the federal court had also held that the criteria for imposing vicarious liability as set out in the English Supreme Court case of various claimants against Catholic Child Welfare Society and others, citation 20132AC1, hereinafter referred to as Christian Brothers case, applies in Malaysia. That is to say that relationships akin to employment are now included in the scope of vicarious liability in addition to employer-employee relationships. So the federal court had explained the difference between the doctrine of non-delegable duty and vicarious liability. The two doctrines are similar in effect in that they both result in the imposition of liability on a defendant. So for example, a private hospital in a medical negligence case, for the injury caused to the claimant, for example, the patient, as a result of the negligence of another defendant, for example, the doctor involved in the care and treatment. However, the doctrine of non-delegable duty and vicarious liability are distinct in nature and basis and are conceptually and practically distinct. Non-delegable duty imposes a personal and direct liability on the private hospital for the breach of its own duty towards the patient on the basis of the relationship between the private hospital and the patient. And the federal court held that the question of whether private hospitals are in breach of a non-delegable duty to their patients by virtue of the negligence of the doctors practicing there cannot be predetermined by a general pronouncement, but determined based on the facts and circumstances of each case, having regard to the defining features in Woodland's case. On the other hand, vicarious liability imposes liability on the private hospital for the doctor's breach of duty towards the patient on the basis of the relationship between the private hospital and the doctor. The federal court had also held that the criteria for imposing vicarious liability as set out in the Christian Brothers case applies in Malaysia, that is to say, that the relationships akin to employment are now included in the scope of vicarious liability in addition to employer-employee relationships. So was there vicarious liability on the part of the private hospital in this case? Ultimately, the federal court held that the private hospital is not liable for the negligence of the defendant doctor because it did not find on the facts that the relationship between the private hospital and the doctor is sufficiently akin to employment so as to give rise to vicarious liability, and that the expanded test in the Christian Brothers case does not extend vicarious liability to truly independent contractors. So the federal court had considered the agreement as between the private hospital and the doctor and found that the doctor's services, including the surgery in question, were generally not subject to the private hospital's control or interference. The doctor was not directed by the private hospital to conduct the surgery in question, but advised and arranged for it in the course of his own practice at his private clinic. The doctor's arrangement with the private hospital was merely to provide for the claimant's admission and the necessary facilities for surgery in question, and that surgery in question was not undertaken on behalf of the private hospital, but attributable to the doctor's own recognizably independent business. In the circumstances, the federal court found on the fact that the doctor is an independent contractor of the hospital, and hence the issue of vicarious liability does not arise. Now, was there non-delegable duty on the part of the hospital in this case? On the issue of non-delegable duty, the federal court found that the defining features of non-delegable duty are not present in this case, and that the private hospital had not assumed a positive duty pertaining to the conduct of the surgery by the defendant doctor, having regard to the facts and circumstances of the case. The federal court found that the facts in the case point against the existence of an antecedent relationship between the claimant and the private hospital. The court found that it could be inferred from the circumstances that the claimant expected the surgery in question to be conducted by the doctor, and that the private hospital had merely provided the facilities required. Now, the facts in Sunway's case are very much in favor of the private hospital, and it is inconceivable that the private hospital could have been held liable, whether on the basis of vicarious liability or non-delegable duty. considering that the claimant had consulted the doctor at his private clinic and that the doctor had advised the claimant to undergo the surgery in question, which happens to have been conducted at the private hospital. Next, we will move on to the eye hospital's case, in which Mr. J.J. Chan and Puan Fasiza were involved. This case was heard together with Sunway's case at the federal court, wherein the federal court had adopted its rationale on the applicable standard of care in medical negligence cases as set out in Dr. Kupu's case, which I have covered earlier on. And the federal court also adopted its observations made in Sunway's case regarding the expanded test for vicarious liability as laid down in Christian Brothers' case and the doctrine of non-delegable duty as expounded in the Woodlands case. So ultimately, the federal court held that the private hospital is not vicariously liable for the negligence of the defendant doctors because it found on the facts that the defendant doctors were acting in the capacity of independent contractors and not employees of the private hospital. And hence, the private hospital cannot be held vicariously liable for their negligence. The federal court had considered the terms of the agreement between the private hospital and the defendant surgeon, as well as the facts. The plaintiff first consulted the surgeon at his private clinic, where the surgeon had advised the plaintiff to undergo the surgery in question, which happens to be conducted at the private hospital. Now, the federal court found no evidence that the private hospital had asserted any control over the surgeon's advice and conduct of the surgery in question, and found that the same was attributable to the surgeon's own recognizably independent business. For the defendant anesthetist, the federal court found that the anesthetist was a visiting consultant and had no clinic within the private hospital. The federal court also found that the private hospital could not interfere the anesthetist's conduct as he was not paid by the private hospital for his services, and that the services were paid by the plaintiff to the anesthetist through the hospital. The federal court said that these factors are characteristics of a contract for services with independent contractors rather than a relationship of employment. Now, on the issue of non-delegable duty, the federal court held that the private hospital is not in breach of non-delegable duty insofar as the defendant, ophthalmologist, or surgeon is concerned, and found that the defining features of non-delegable duty are not present, essentially because on the fact there was no assumption of responsibility by the private hospital for the conduct of the operation in question by the surgeon, and that the plaintiff had chosen and consulted the surgeon at his private clinic prior to his admission to the private hospital for the operation in question. However, the federal court held that the private hospital is in breach of non-delegable duty insofar as the defendant anesthetist is concerned, and found that the defining features of non-delegable duty are present, essentially because on the facts, the private hospital had assumed a positive duty to the plaintiff to ensure that reasonable care be taken in the provision of anesthetic services through the anesthetist, and that the anesthetist was negligent in the conduct of the duty delegated by the private hospital to him. So in this case, the patient requested specifically for one Dr. M, the anesthetist who attended to her during the first eye operation. However, Dr. M was on maternity leave. As such, the hospital assigned another anesthetist whom the patient did not know and did not ask for. As such, the federal court found that the private hospital, being the provider of anesthetic services through the anesthetist, had assumed a positive duty to the plaintiff to ensure that reasonable care was taken in the provision of such services by whomever the private hospital engaged to do so. So the federal court found that the plaintiff had no control over how the private hospital chose to provide the anesthetic services, could not be expected to know the internal arrangements between the private hospital and the anesthetist, and that the private hospital had delegated to the anesthetist the responsibility to keep the patient anesthetized during the surgery in question, which is an integral part of the positive duty assumed by the private hospital to the plaintiff, and the anesthetist was negligent in the performance of the very duty delegated by the private hospital to him. Consequentially, the federal court found that there was non-delegable duty on the part of the hospital. I will next move on to Adventist Hospital's case, in which Mr. J.J. Chan and Puan Fasiza were involved as well, and we acted for Penang Adventist Hospital. So this is the first decision by the Court of Appeal in a medical negligence case that referred to and applied the landmark decisions by the Federal Court in Sunway and Eye Hospital's case on the expanded test of vicarious liability and the doctrine of non-delegable duty. In so doing, the Court of Appeal overturned the High Court's decision below and ultimately found that there was no non-delegable duty on the part of the private hospital for their independent contractor doctors. Now, the Court of Appeal, in holding that the hospital was not vicariously liable, essentially held that the defendant orthopedic surgeons are independent contractors, not agents or employees of the hospital, and that they operate independent businesses of their own, free from the control and management of the hospital. Now, the Court of Appeal, in holding that the hospital was not in breach of non-delegable duty for the negligence of the defendant orthopedic surgeons, essentially held that, number one, the issue of non-delegable duty on the part of the private hospital was not pleaded in the statement of claim, and that in any event, there was no antecedent relationship between the private hospital and the patient and or her parents, and that the patient and or her parents had chosen the lead orthopedic surgeon, who in turn had brought in the other orthopedic surgeon to be involved in the surgery in question. Now, incidentally, this is the first medical negligence case, to our knowledge and understanding, where fresh expert medical evidence was allowed to be adduced at the appellate stage for the purpose of addressing the current condition and prognosis of the patient with regard to quantum of damages. In this regard, the Court of Appeal had, after considering the fresh expert medical evidence adduced by the parties, reduced the quantum of damages awarded by the High Court judge accordingly. Now we come to Columbia Asia's case. It was recently reported in the news that the federal court found the private hospital concerned in breach of non-delegable duty for negligence of its anesthetist and consequently awarded special and general damages against them. Now, in its majority opinion, the federal court referred to its previous decisions in Sunway's case and Eye Hospital case and held that the doctrine of non-delegable duty of care, as well as the defining features of the same, as expounded in Woodland's case, remains applicable. Now, the Columbia Asia case is an emergency services case. The patient was brought to the A&E department and left it to the internal mechanism of the hospital for care and management. So he was treated by the medical officer, and the medical officer then referred the patient to the ENT surgeon and anesthetist for treatment. So the federal court found on the facts that there was an assumption of responsibility for the patient and consequently found that the hospital was in breach of non-delegable duty for the negligence of the anesthetist. Now, as regards the ENT surgeon, the issue of non-delegable duty did not arise as we acted for the surgeon, and after a full witness trial, managed to have the claim for negligence against him dismissed as trial, with the appeal at the Court of Appeal ultimately struck out. So, in light of the appellate court decisions which I have shared with you in this session, it can be seen that even if private hospitals do manage to disavow liability for the doctor's negligence in respect of vicarious liability, arguing that the doctors are merely independent contractors, which is conventionally the stand taken by private hospitals. Private hospitals may, however, be found liable on the basis of non-delegable duty, which would very much depend on the facts and circumstances of each and every case, with the plaintiff's personal choice of doctor being an important feature of consideration. So that essentially sums up the significant landmark medical negligence in cases. And before we move on to the Q&A segment, I wish to share that the articles, as well as our overview, is for the information of the participants and deals with issues generally, and wish to state that our views and comments in this session, including the Q&A segment, would not constitute nor are they intended to be a substitute for legal advice on specific matters. So I now invite our managing partner, Mr. J.J. Chan, to say a few words.
Hi, good afternoon, everybody. May I, on behalf of all of us here, thank the Lloyd's team for organizing today's session and inviting us to share our views on the relevant medical negligence cases. I trust that Phoebe has covered the legal issues adequately. I don't plan on saying much, except to add, if I may, that Dr. Kupu was a welcome decision because for quite some time there was uncertainty as to the applicable standard of care in medical negligence. The federal court clarified that the English Bolam test would apply to diagnosis and treatment, whereas the Australian Rogers test would apply to duty to advise, or otherwise known as failure to warn cases. I would also like to add, and by the way, we get asked this quite a lot, that private hospitals are not vicariously liable for the doctors who are independent contractors. However, they may be liable for the independent contractor doctors on the basis of non-delegable duty if the defining features are present, that is to say, there is an antecedent relationship as between the patient and the hospital, which gives rise to an assumption of responsibility for the patient. You may recall Phoebe mentioning that the Adventist Hospital case had allowed for fresh expert evidence to be adduced at the appellate stage. Now, this is a rather important ruling because in most, if not all, medical negligence cases, the trial judge would hand down a lump sum award, which invariably takes into account future care expenses, notwithstanding that the patient's condition and medical needs may change subsequently post-judgment. With fresh expert evidence, the appellate court would be apprised of the patient's current condition and prognosis, together with his or her medical needs, and consequentially be in a position to evaluate and revise the award of damages if necessary. This would prevent excessive damages and unjust enrichment, bearing in mind that general damages are meant to be compensatory in nature and commensurate with the condition and circumstances of the patient following an incident of medical negligence. That pretty much sums up what we have to say. Thank you for your time. Are there any questions?
Hi, JJ and Phoebe. Thank you very much for all of this. And I appreciate your time to be here with us today. And I guess one of the few things, or rather a question that came about within our chat itself is that seems to be some recent news article commenting that the federal court's decisions, which I believe it referring back to the Columbia case itself, that to hold, is it the decision to hold a private hospital liable for medical negligence could have an adverse effect on private healthcare that would see a rise in defensive medicine. Do you have any comments to actually be made on this point?
Okay, that is a very broad question. So I will do my best to address that question. First of all, I would like to say that the Columbia Asia case, with respect, contrary to what a lot of people may say or may think, to us, we say does not really create any new law, as it were. The cases, as highlighted by Phoebe in her overview, in particular, the Sunway Eye Hospital cases, including the Adventist Hospital case, has really brought in the expanded test for vicarious liability and the doctrine of non-delegable duty as expounded in the English Supreme Court cases of Catholic Welfare, Child Society, and Woodland, which has been around for, I suppose, 7 years now, in the UK for the past 10 years. It may be the case, I'm not sure about this, I'm just speculating that those cases did not get wind of the press or it was not informed to the press, I'm not sure. So it was not widely reported in newspapers. But the law has been as such for the past 7-8 years, I would say, in terms of vicarious liability, in terms of non-delegable duty. In short, these are not new concepts of law. And following that, I shouldn't think that there should be any, wide changes or massive repercussions, as it were. I would also like to say that if I may, that the Columbia Asia case, as Phoebe has highlighted earlier, is an emergency services case. At the risk of repetition, the patient was brought into the A&E department and left it to the internal mechanism of that hospital for care and treatment. The medical officer, obviously an employee of the hospital, referred the matter to the ENT surgeon we acted for and the anesthetist. So this is clearly a case in which the antecedent relationship has been first formed with the private hospital rather than the doctors, in this case, the ENT surgeon or the anesthetist for that matter. In fact, if I may, this scenario, meaning to say in the Columbia Asia's case, had been highlighted in the written reasons for decision by His Lordship Rao Sharif, the then Chief Justice, in the Sunway case, citation 2017, 10 CLJ at page 529, paragraph 67, E to F, and may I quote, "This scenario can be contrasted with a hypothetical situation where a patient enters a hospital and relies upon the latter's internal systems to be referred to any suitable doctor on duty. In that situation, the hospital, having accepted the patient and undertaken to treat him, may well be under a non-delegable duty to ensure that he's treated with care by whomever the hospital engages to do so." End of quote. So this has already been observed in the Sunway's case, as I said, about 7 years ago. So it's nothing new, and the facts in the Columbia Asia's case, again, at the risk of repetition, is pretty much clear that non-delegable duty would apply, having regard to the criteria or indicia fixed by His Lordship Jonathan Sumption in the Woodlands case, as brought into Malaysia via Sunway and the High Hospital cases. You mentioned, Wayne, about the concern of defensive medicine. And it just so happens that I wrote something about this, I think in the materials. So let me just refer to this. And I think the passage, which is rather pertinent, is extracted from the English Supreme Court case of Montgomery against Lanarkshire Health Board, Scotland, citation 2015 UKSC 11. Although it was addressed and decided in the context of the law of duty to advise, there was reference to the issue of defensive medicine. And this is what the Supreme Court had to say, and if I may quote, "Insofar as this contributes to the incidence of litigation, an approach which results in patients being aware that the outcome of treatment is uncertain and potentially dangerous, and in their taking responsibility for the ultimate choice to undergo that treatment," now this is important, "may be less likely to encourage recriminations and litigation in the event of an adverse outcome, as compared to an approach which requires patients to rely on their doctors to determine whether a risk inherent in a particular form of treatment should be incurred." So again, as I said, that may be in the context of duty to advise of material risks. In Singapore, it's the duty to advise of information following the Section 37 of the Civil Law Act. I think the point here, specifically as regards defensive medicine, is if the patient has been advised of the risks, prognosis, and etc. of a particular treatment or reasonable alternative treatments and enters into a collaborative process with the doctor and ultimately makes his or her decision based on available information, complete information, that if something adverse were to occur, it is less likely, well, in principle, that the patient would file a claim for negligence against the hospital. So that is in terms of defensive medicine. But if you come back to, I apologize if I digress, but that is, I think, a very pertinent point to share on defensive medicine. We get asked this a lot, by the way. But in terms of this concept of vicarious liability and non-delegable duty, as I've said, it's nothing new. And I don't think that it should, result in defensive medicine. I don't see how that would change matters really, because my view, and I'm sure this applies to all medical professionals, I'm sure this applies to all private hospitals or government hospitals, is that they would do their utmost as per the standard of care that's required of them. So I don't think that it should really change. What may change, if I may add, and this is my view and my firm's view, is that perhaps with these cases, it may affect as to who ultimately may have to pay for damages. Meaning to say, if there is no vicarious, if the hospital is not vicariously liable, then obviously something gone wrong, the doctor and or the insurer will have to pay. If there is non-delegable duty, then it would be the case that the hospital and the doctor will both have to be responsible for the damages handed down. So I think that's about it. I don't really foresee significant changes in that regard. I hope that answers the question, or I'm not sure if I share a bit too much, but
thank you.
Our experience with it.
Sure. Thank you very much for providing your comments on defensive medications, defensive medicines, and also your views on who ultimately have to pay. As you have kind of bring forward the part on Colombia case, someone else has also raised this in a two-parts question. The first part of it is that in Colombia's case, the anesthetic and the ENT surgeons were both independent doctors, but yet why was the anesthetist being liable for it? And the second part to it is that there's no directions by the federal court on apportionment of liability between anesthetists and Colombia. So how was this then to be dealt with? That is, if there's payment of is to be 4.5 million, the judgment sum of cost was being made to the patient.
Okay, so let me just address it this way. As I've mentioned earlier, when it comes to independent contractors, there's no vicarious liability. And we get asked this a lot, as I said. So that is why there was no liability in that regard. However, as I've highlighted as well, the hospital may still be liable for the independent contractor doctors on the basis of non-delegable duty. So non-delegable duty is developed out of vicarious liability. It is a way to extend liability to principals, in this case, private hospitals, for the doctors. I would add as well that non-delegable duty came about to address the principal limitation of vicarious liability, and that is the defense of the tortfeasor, who is an independent contractor. So in Columbia Asia's case, there may not be vicarious liability on the part of the hospital, but there was a finding of non-delegable duty instead in respect of the anesthetist negligence. I think Phoebe may have mentioned to you, in terms of the ENT surgeon, the issue of vicarious liability did not arise because we managed to defend him at the trial, and the appeal was subsequently withdrawn. So it's just the anesthetist. And as to why he's liable, as to why the hospital is liable, that goes back into the law, where we talk about whether there's an antecedent relationship between the patient and the hospital, which gives rise to an assumption of responsibility. So in this case, again, as I've said, the patient was brought into the A&E department of the hospital, left it to an internal mechanism. It's not as though the relationship was first formed with the anesthetist or the surgeon, in which case non-delegable duty will not arise following the decision in Sunway and Tun Husenon and Adventist Hospital cases. So the federal court found that the anesthetic services were meant to be provided to the patient. In this case, it was provided through the anesthetist. At any rate, the relationship is first formed with the hospital at the A&E department. So there is non-delegable duty. In terms of the apportionment of damages, when it comes to non-delegable duty, if at all there is non-delegable duty, the judgment handed down would be what is called a joint and several liability award. That basically means that the doctor and the hospital will have to bear full responsibility for the whole judgment. So if it's $1 million or $5 million ringgit, sorry, both parties were to bear full responsibility. There's no apportionment of damages, as it were, because the concept of non-delegable duty is that the private hospital had the duty to treat the patient, but it delegated that duty to someone else, and that someone else got it wrong or there was negligence. And as such, the law imposes personal and direct liability on the hospital, which means that he's fully liable along with the doctor. So there's no apportionment of damages. So the next point probably we'll be asking is then who decides who pays how much? Really? But that is a very good question, and we dealt with it in the Adventist Hospital case as well. And I suppose it's up to parties to negotiate compromises to produce an outcome which would benefit clients' interests. That's what I can say. But it will be on a case-by-case basis. So yeah, that's something that has to be worked out. You may even have a situation I can share with you, because we experienced this, whereby the claimant could choose to enforce the judgment against one party, for example, the hospital or the doctor. And that is his prerogative. He can do so. The hospital or the doctor can't say that, listen, why don't you go after someone else instead? That is the claimant's right. So that is how it works. If you'd like me to clarify a bit more, a portion of damages usually works more if, let's just say, two doctors are sued, like in the Adventist Hospital case, and the court ultimately found that one of the doctors is liable to the extent of 35%, and the other is 65%. So that is because both parties may have done something wrong. Perhaps the first doctor did something which was not quite right, and then the second doctor compounded matters by doing something else. That is when the apportionment of damages comes in. But there will be no apportionment of damages when it comes to vicarious liability or non-delegable duty.
Okay, thank you, JJ, and thank you for sharing that non-delegable duty itself is developed out from vicarious liability. And from that onwards, even though this has been ongoing for about 7 years since the initial case itself that was heard in 2017, which I believe it was a Sunway one, just wondering itself, have you seen an increase of pleadings on non-delegable duty on the part of private hospital?
That's a good question. And the simple answer to that is, I believe, no. Because even prior to the decisions in Sunway and Eye Hospital and Adventist Hospital cases, the claimants have already put forward the case for vicarious liability and non-delegable duty way before that. It's just that it never reached the federal court for determination and for criteria to be fixed, and more importantly, specifically for the federal court to address whether these concepts should come in. So even though I appreciate that the Woodlands case is decided, if I'm not mistaken, in 2013 by the Supreme Court, which is 11 years ago. Prior to that, I hope I'm not going to bore you into this, but this goes into the law. But this doctrine of non-delegable duty in hospital cases has already been discussed in the 1950s in what is called the trilogy of cases in Gold, Cassidy, and Rowe. 1942, 1953, 1955, or 54, I'm not mistaken, decided, the latter cases decided none other than His Lordship, Lord Denning, which I suppose a lot of them may have heard about. So it's not something new, and it's already there. It's just that in the Woodlands case, His Lordship, Jonathan Sumption, fixed the criteria, or what he calls the defining features of non-delegable duty. So that in that sense, it's easier to decide whether or not non-delegable duty would arise, if you follow A, B, C, D, E. So that's in the judgment. So to summarize and to reiterate, I don't see any increase, and I don't imagine there should be any increase in the pleadings, in particular on vicarious liability or non-delegable duty.
Thank you. Thanks a lot, Gigi. And I think just one last point, just to add on a little bit, hearing from you, knowing that it doesn't really change in the landscape for the increase of pleadings, but just wondering if you've seen any potential implications on patient care or even hospital operations due to the imposition of this non-delegable duty. I somewhat know the answer to it, but yet I would like to hear from you again.
You see, that is a tricky question, Wayne, because you're asking me in my capacity as a lawyer and what we feel. So I personally feel, as I said, there should be no change, which, based on what I've told you before, that I respect all medical professionals, including private hospitals and general hospitals, that they would do whatever is necessary and whatever is best in the patient's interest. Okay. Having said that, of course, we do get questions from private hospitals and other hospitals as to what can be done to prevent this, since they may be more liable, they may be liable as well, even though the doctors are independent contractors and etc. But my answer to that is, basically beef up the system, get things better, and improve on the care and treatment given. And I don't see how they can change it. And I can see that they appreciate that as well. So I don't think they're really, this is from our experience anyway, I don't see there's any real change there. And they also understand now in a way where maybe perhaps this is where you may come in, weighing, where they appreciate more that good insurers or reinsurers are important. Because most of the time, if not all the time, if they get sued, damages will be paid by the insurers, unless within an excess amount, you see. So I share with them as well that nothing would change except for perhaps to make sure that you're properly indemnified, in that you may be liable to pay damages in circumstances which you thought previously you would not be liable. Specifically, cases where your independent contracted doctors may have committed negligence. Now you may be liable. So I think that's what they're taking stock and making sure that they're properly indemnified. And I think that's about it. I don't see what changes there can be, to be honest. But that's just my view. So I stand corrected.
Sure. Thank you very much, JJ, for sharing your views and all the questions on hand. I believe I have kind of reached almost to the tail end itself on this, and we have answered the respective questions that has been raised. So if there's anything else, please do let us know accordingly, and we can address them while we have still a few minutes away. So, yep.
Thank you, Wei Ying, and thank you, Phoebe and JJ, for enlightening us on the landmark cases on medical negligence and for sharing those articles with us today as well. For our regular listeners, they would know that I always ask this at the end of the session. What is one key message that you want our audience to remember from today's session? Do you want to start first, JJ?
Who else is going to go except me?
Phoebe, next.
I think that, I mean, if I may, Phoebe, would you like to say something or shall I do it? You're on
Please go
silent.
ahead, Mr. JJ.
Okay, so I think Shara, I sort of anticipated this, having done this. This is not my first rodeo, as you know, but so what I did in the when I spoke initially, if you recall, I actually summed up what are the key takeaways. Phoebe has done an excellent job, I feel, in her overview. So I believe I've done that when I spoke a bit before Q&A, but at the risk of repetition, I think I think the key takeaway probably in terms of the hospital's liability would be that in view of the uh, significant medical negligence cases, we say that if private hospitals do manage to disavow liability for the doctor's negligence, in respect of vicarious liability, conventionally on the basis of on the basis of them being independent contractors, they may, however, still be found liable on the basis of non-delegable duty, which will very much depend on the facts and circumstances of each and every case, but with the plaintiff's personal choice of doctor being perhaps an important feature for consideration. I think perhaps that's what we will say. Phoebe,
Great,
what do you
thank
think?
you. Phoebe, any thoughts?
Yes,
Last
thank you for that.
comments?
So I think what we've covered today are the significant landmark medical negligence cases. And you may like to read our comprehensive views on the same. I believe they are uploaded in the chat. And yeah, I think that sums up today's session. Thank you.
Right. Thank you, Phoebe, once again, and JJ for that very insightful thoughts and to weighing as well. And thank you, everyone, for your participation and support in our educational programs. And we're happy to share that we have over 1,000 attendees across the Asia Pacific, Middle East, and Africa for the July series. And it's always our pleasure to bring you all these educational opportunities. So feel free to send us your feedback through the QR code, which I will be sharing later on. And for those who have already sent in the past, thank you. We hear you and we will look into all those interesting suggestions that you have provided us, along with your certificates, which we are still in the progress of sending through. All right, with that, we will wrap up today's session and we look forward to seeing you all again next week. Same time, 3 to 4 p.m. So next week, our session will be on about power generation losses during energy transition on the 6th of August and flood claims across Asia on the 8th of August. All right, registration is still open for those, so feel free to register and reach out to Lloyd's if you are interested. Right, thank you very much, everyone, and I will be sharing my screen for the feedback form. Thank you, and see you next week. Bye.
Yes, Shara.
Thank you.
Thank you.
Anyway.